Section 29, Legal Hotline Q&A Part 6, Introduction, Bringing Agency Full Circle. Throughout this course, we have examined agency relationships from every angle. We have discussed buyer representation, seller representation, implied agency, dual agency, fiduciary duties, procuring cause, compensation, disclosure requirements, unlicensed assistance, and the responsibilities brokers owe to their clients and the public. If there is one lesson that emerges from all of these topics, it is this. Agency is built on trust. Clients trust agents to protect confidential information, avoid conflicts of interest, provide honest guidance, and act within the limits of the law. The final legal hotline questions in this course highlight many of the mistakes that can occur when agents forget those principles. These scenarios serve as a fitting conclusion because they bring together many of the agency concepts we have studied throughout the course. A dual agent cannot share pricing information. One of the most difficult situations in real estate occurs when a broker represents both parties in a transaction. Imagine a listing broker receives an offer from buyer A. Because of the circumstances, the broker becomes a limited dual agent. Before the seller responds, another offer arrives from buyer B. The seller instructs the broker to tell buyer B exactly what buyer A offered, so buyer B can submit a stronger offer. Can the broker do it? No. The consent to limited representation form clearly states that a broker may not represent one party to the detriment of the other. Revealing the amount of buyer A's offer would place buyer A at a disadvantage and therefore violate the limitations imposed on a dual agent. This is an important reminder that a dual agent does not have the same flexibility as a traditional single agent. Once dual representation exists, the broker's ability to disclose information becomes significantly restricted. Throughout this course, we have repeatedly discussed that dual agency limits advocacy. This legal hotline example demonstrates exactly why those limitations exist. Real-world example: the seller wants more money. A seller receives an offer for $500,000. A second buyer is preparing an offer. The seller tells the dual agent, tell the second buyer exactly what the first buyer offered. The broker cannot do so if the disclosure would harm the first buyer's interests. The broker's role is not to favor one party over another. The broker's role is to remain neutral while complying with the duties established in the Consent to Limited Representation Agreement. Unlicensed employees cannot discuss lease terms. In the previous section, we spent considerable time discussing the limits placed on unlicensed assistants. Another legal hotline question reinforces those same principles. A property management company employs an unlicensed assistant who answers calls from tenants. A tenant calls and wants to discuss lease renewal terms, rental rates, and possible modifications to the lease agreement. Can the assistant have that discussion? No. Arizona Department of Real Estate policy clearly limits the activities of unlicensed individuals. While assistants may schedule appointments, deliver documents, and perform administrative duties, they may not discuss lease terms, negotiate agreements, answer substantive questions regarding transaction documents, or renew leases. The reason is simple. Discussing lease terms requires judgment, negotiation, and real estate expertise. Those activities require a license. A licensee may only work for the broker with whom they are licensed. Another common agency issue arises when an agent changes brokerages. Imagine agent Sarah leaves brokerage A and joins brokerage B. One of her former listings remains with brokerage A, and the designated broker asks Sarah to continue servicing the client while receiving compensation through the former brokerage. Can she do it? No. Arizona law provides that a licensee may only perform real estate services on behalf of the broker with whom the licensee is currently licensed. Once Sarah transfers her license to brokerage B, she cannot continue providing real estate services for brokerage A. This rule helps eliminate confusion regarding supervision, agency relationships, and broker responsibility. As we learned earlier in the course, agency flows through the broker. Therefore, it is critical that clients, consumers, and the public know exactly which broker is responsible for the agent's actions. Agency disclosure applies to rentals. Too many agents mistakenly believe agency disclosure is only required in residential sales transactions. The legal hotline reminds us that this is not true. Agency disclosure also applies when representing landlords and tenants. Whether assisting a buyer, seller, landlord, or tenant, agents should discuss agency at the beginning of the relationship and properly document that discussion. The same principles of disclosure, loyalty, confidentiality, and informed consent apply regardless of whether the transaction involves a purchase contract or a lease agreement. Agency law is not limited to sales. It applies to representation itself. When does an agency relationship end? One of the most important questions in agency law is determining when duties end. The legal hotline addressed a situation involving a broker who had previously listed a property. Years later, the broker purchased neighboring property and planned a new development. The former client argued that the broker still owed duties arising from the old listing relationship. Generally, agency relationships terminate when the listing agreement expires or the transaction is completed. However, one duty survives: confidentiality. A broker may not use confidential information learned during a prior agency relationship against a former client. This concept has appeared repeatedly throughout this course because confidentiality remains one of the strongest and longest-lasting fiduciary duties. Helping a FSBO can accidentally create agency. One of the most dangerous agency traps occurs when dealing with for sale by owner transactions. Imagine you represent a buyer purchasing a FSBO property. The seller signs an unrepresented seller consent form acknowledging that you represent only the buyer. Everything seems clear. Then the seller begins asking questions. What price should I accept? What repairs should I agree to? How should I respond to the BINSR? What should I do about title issues? The agent wants to be helpful and starts answering those questions. This is where problems begin. Arizona courts recognize that agency relationships may be implied through conduct. In both Warren versus Mangles Realty and Haldeman versus Gosnell, the courts acknowledged that an agency relationship can arise from actions rather than formal agreements. By advising the seller, the buyer's agent may unintentionally create an implied agency relationship with the seller. The result? Potential dual agency, potential conflicts of interest, potential violations of fiduciary duties. The safest practice is to politely remind the seller in writing that you represent the buyer only and encourage the seller to seek independent advice. The final lesson: as we conclude this course, it becomes clear that agency law is not about memorizing forms or checking boxes. Agency is about relationships. It is about understanding who you represent. It is about protecting confidential information. It is about avoiding conflicts of interest. It is about providing honest and professional service. It is about knowing when to act and when to step back. The best agents are not necessarily those who know the most rules. The best agents are those who consistently apply agency principles in every interaction with buyers, sellers, landlords, tenants, and consumers. Throughout this course, we have explored the many do's and don'ts of agency. While laws, forms, and industry practices may continue to evolve, the foundation of agency remains unchanged: loyalty, disclosure, confidentiality, obedience, reasonable care, honesty. Agents who embrace these principles will not only reduce risk, but will also build stronger client relationships, stronger reputations, and more successful careers. Congratulations on completing do's and don'ts of agency. The knowledge gained throughout this course will help you navigate agency relationships with confidence, professionalism, and a commitment to protecting the interests of the clients and consumers you serve. Online discussion questions. Question 1. Why can't a dual agent disclose the amount of one buyer's offer to another buyer? Answer: because doing so would favor one party to the detriment of another and violate the limitations imposed on dual agency. Question 2. How can a buyer's agent accidentally create an agency relationship with a FSBO seller? Answer: by providing advice, recommendations, or guidance regarding negotiations, pricing, repairs, or contract terms, which may create an implied agency relationship. Question 3. Which fiduciary duty generally survives after an agency relationship ends? Answer: confidentiality generally survives the termination of the agency relationship.